Mr. Jones, anything you want to say?
I didn't realize how badly I've screwed up until hearing it all out loud. I kept apparently getting myself into thinking that I wasn't so bad, but apparently I'm a monster. I've never meant to hurt my wife or my kids. I apparently just got into bad rationalization. I don't know what else to say.
Mr. Jones walked into court and admitted his guilt, pleading guilty to weapons charges and violating a protection order. But the hearing took an emotional turn when his wife described years of fear, manipulation, and threats, revealing why she is now seeking a divorce and permanent protection for herself and her children.
All right, these are case numbers 24-CR-42167, 26-CR-43461, State of Ohio versus Christopher Jones. Mr. Jones is before the court with his counsel, Mr. Helbling. Ms. Nicholson on behalf of the State of Ohio. Under 43461, Ms. Nicholson, what are we doing?
Your Honor, it's my understanding the defendant will be entering a guilty plea as charged to one count of having weapons under disability, a felony of the 3rd degree, and one count of violating a protection order, a misdemeanor of the 1st degree.
All right, Mr. Helbling, is that accurate?
That's accurate, Your Honor. Thank you.
All right, Mr. Jones, you're telling me you're going to change your plea to guilty to the 2 counts of the indictment. Before I get to your change of plea, I am required to go over some things with you, sir.
Yes.
How old are you?
43,
How far did you go in school?
a little bit of college.
So you can read and write, yes?
Yes, sir.
You're a citizen of the United States.
Yes, sir.
Has anyone promised you how the court would sentence you in this matter?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you currently under the influence of any drugs or alcohol?
I don't believe so. I mean, I'm on an antidepressant, but that's it.
Well, do you take any drugs that makes you unable to understand what's going on today?
I don't believe so.
All right. I have in front of me a document called a change of plea. On the second page on the line marked defendant, there appears a signature. Did you sign this?
Yes.
You read this and went over it with Mr. Helbling?
Yes, sir.
And you feel comfortable that you understand what it says?
Yes.
All right, this document says you're entering a plea of guilty to one count of having weapons while under disability, a felony of the 3rd degree carrying a maximum penalty of 36 months in prison, and a maximum fine of $10,000. The second count is one of violation of a protection order, a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalties involved?
Yes, sir.
In addition to those penalties, you're also subject to a discretionary period of post-release control, which means when you are released from prison, upon your release, the Adult Parole Authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify if you can choose not to testify in your case in chief. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. You understand that?
Yes, sir.
The burden of proof is on the prosecutor at your trial. You're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
This is how you want to proceed.
Yes, sir.
Ms. Nicholson?
Your Honor, if this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about Warren County probation officers had overheard and intercepted jail phone calls by the defendant requesting that a friend of his retrieve what they believed to be referring to firearms that he had hidden in his residence. They were able to confirm that the friend was at the residence. Law enforcement and probation intercepted the friend who, in fact, had retrieved a loaded .380 from the residence that had been underneath the floorboards in the crawl space. The defendant has a prior conviction for a crime of violence that was a felony. Additionally, on February 27th, 2026, the defendant made a phone call from the jail to Sarah Jones, who is currently the subject of a protection order protecting her from Mr. Jones that had been served upon him. She did not pick up the call. Jail records confirm the call was made.
Mr. Helbling, anything on those facts?
Nothing on the facts, Judge, thank you.
Mr. Jones, did you hear the statement that she read?
Yes.
Do you admit that what she said is true?
Yeah, what it is, I fat fingered the wave button and I couldn't take that back on the machine. It's not that I actually called her. When I was scrolling through, I hit, and it was an accident.
All right, you understand all the rights you're giving up when you enter a plea of guilty?
Yes, sir.
And what is your plea?
Guilty.
All right, court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty. Based upon the statement of facts in your plea, the court will make a finding of guilty. As to case number 24CR42167, Mr. Helbling, does your client wish to have a hearing on the allegations that he violated the terms of his community control?
No, Your Honor.
Mr. Jones, you understand you're entitled to have a hearing on that allegation as well.
Yes, sir.
You wish to waive that hearing and admit to the violation?
Yes, sir.
All right. The court's going to find that you have violated the terms of your community control. Ms. Nicholson, anything before I sentence Mr. Jones?
Yes, Your Honor. Ms. Kennard does have a letter from the victim. After having further discussions with the victim during these proceedings as they've been ongoing this afternoon, she has asked Ms. Kennard to read that letter to the court.
Okay.
Your Honor, my name is Sarah Jones, and I am the wife of Christopher Jones. I am writing to clarify my position and to ensure that my voice and perspective are accurately understood by the court. I think that there may have been some confusion regarding my views. I have spoken to the advocates with the prosecutor's office many times to voice my concerns and provide my perspective. I had been hesitant in allowing the prosecutor or advocates to communicate to the court directly what my views were, which was solely out of fear. I want to be clear that my prior hesitation to have my statements shared in court was not because I support Chris or his actions. Rather, it was due to fear, being overwhelmed, and out of concern for my safety and privacy and that of my children during an already extremely difficult and volatile time. Since these events, my life has been significantly impacted. I have taken steps to protect myself and my children, including pursuing a civil protection order and beginning the process of separation and divorce. I have retained a divorce attorney, but a divorce complaint has not been filed yet. To my knowledge, nothing has been communicated to Chris regarding impending divorce proceedings. This is because I have kept that information mostly private from friends and family as I go through this process, and due to the civil protection order and no contact order that is in place. These decisions were not made lightly, and they reflect the seriousness of the situation and my need to prioritize safety and stability. I have been subjected to manipulation, aggression, violence, and blame by Chris for many, many years. I have been conditioned to just do anything and everything I can to keep him from becoming upset or angry in any way. Centering my life around that became necessary to just be able to live safely in my own home. My primary concern has always been the safety and stability of my children. And I have been stuck in the delusion that if I can just endure the mistreatment and keep anything from upsetting him, then I can protect my kids from his behavior. But his aggression and violence have escalated so much recently, and it's become clear that it wasn't sustainable or possible to continue to try to keep the peace. and that I could not keep myself and my kids safe while living with Chris. That is when I had to file for a protection order against Chris in February of 2026. There were many instances of intimidation, abuse, sexual coercion, and assault that led up to this. But the last straw event that led to the protection order was a very bad fight on February 20th. Chris was very drunk and got extremely upset when I denied his request for intimacy. The fight escalated to him tearing up the house, breaking a picture frame, and trying to get to what he said was a weapon he had hidden in the house, which turned out to be true. He threatened to kill himself, which he has a history of doing very often as a way of manipulating me into giving in to whatever he wants at the time. My children were asleep in the room at the time, and I was too afraid to call the police during the fight. When I filed for the protection order, I explained this fight and many incidents of aggression and violent behavior, including his recent court case, to Magistrate Webb. The magistrate asked me how long I wanted the protection order for, and I told him that I was too afraid and overwhelmed to know how to answer, and that I would request the court grant it for as long as the court felt was appropriate given my testimony. Magistrate Webb granted the protection order for the maximum amount of 5 years. I also want the court to understand the reality of my circumstances. Chris and I share children, and as long as they are minors, I cannot completely remove him from my life. I am mindful that I will likely have to navigate some level of interaction with him in the future. While I am not seeking to prevent him from having a relationship with his children, my foremost concern is their safety and well-being, as well as my own. All of my attempts in the past to just keep the peace and endure everything I could to try to keep my children safe were all out of fear, since I so desperately do not want the subject of my children to a future. I don't want to subject my children. I lost my place. I don't want to subject my children to a future of high conflict custody disputes and putting them in a dangerous position where I thought I would not be able to protect them. I had been so afraid that leaving would be more dangerous than staying. But now it is clear that it is very much at the point where staying is not possible or safe, and that I am still afraid every single day that anything I do or say that will get back to him will anger him and put me and my children in danger in the future. Additionally, I am concerned that my presence at prior proceedings and any perceived lack of opposition may have been interpreted as support for Chris. That is not accurate. Any statements I made to Chris's attorney, Mr. Helbling, were made either in Chris's presence or with the understanding that they would be relayed to him. At the time, I was afraid to say anything that would upset him. I am aware that this letter will be reviewed by Mr. Helbling and potentially shared with Chris. I want to respectfully acknowledge that prior communications with his attorney were made under the context of fear, concern for my safety, and concern for my children's safety. I also want to express how difficult this letter is to write, especially considering my history of being conditioned to do nothing that angered Chris, and given the awareness that this letter's contents could be or will likely be shared with Chris. That fact is frankly terrifying and only contributes to fearing for the safety of myself and my children. I hope that context is understood by the court and by Mr. Helbling. Throughout the original proceedings, I did express my concerns and perspectives directly to Chris. Those conversations were often met with anger, blame, manipulation, and accusations that I did not understand or support him, and that I was at fault. This dynamic contributed significantly to my fear and to my reluctance to speak openly in settings where my statements could reach him. Again, I was just stupidly trying to endure and keep the peace in hopes that we wouldn't be subjected to his anger. Chris has an ability to be a manipulative person and present himself as very apologetic, remorseful, and as a victim where he's present in court, but then act the opposite outside of court. I've witnessed this countless times over the years, and especially with his recent court cases. Last year, during the time leading up to his December 2025 trial, Chris continuously spoke in such a terrible, hateful, and violent way about the officers of the Springboro Police Department, members of the court and prosecutor's office, and his first public defender, Anna Castellini. I witnessed him speaking on the phone with Anna on June 8th, 2025, where he was screaming at her, berating her, and threatening her only because she rightfully expressed her professional opinion that he should take whatever plea bargain was offered to him rather than go to trial. He threw the phone at me while he was still on the line and left the room. I apologized to her, and after I hung up, Chris said that he wanted to stab her in the face. Anna did not show up to the scheduled June 9th conference with the court after that. At the time, the court was not aware of the reason, and that is when Mr. Helbling was assigned as Chris's new public defender. Chris went through the entire process before, during, and after December 2025 with extreme arrogance that he did nothing wrong and that he would not face any real consequences. I believe he has the same opinion now, that he will be able to escape these charges with no additional consequences. Chris will often speak very apologetically and remorsefully in settings like jail phone calls or in conversations with friends or family. He did this during his 13-day jail sentence in December of 25 after his trial conviction. He made a lot of promises that he would change, but he was back to his typical behavior as soon as he was released. In fact, he got into a fist fight with his cousin 2 days after his release in January of 26. He has a long history of saying whatever he thinks anyone, me, the court, friends, etc., want to hear in order to let him off without consequences, and then he immediately goes back to his same aggressive behavior. I do not support or condone Chris's actions. My primary focus has been and continues to be protecting my children, maintaining stability in our lives, and ensuring our safety moving forward. It is my personal opinion that should Chris be convicted of his current charges, and of course, if the court sees fit, a jail sentence and the continuation of the no contact order and civil protection order will be the best way to keep me and my children safe. I truly feel that any other sentence will not result in Chris making any meaningful change. Despite all of this, I am not a hateful person. I truly hope that Chris is able to better his life for his own sake in the future. However, that should not minimize or discount my genuine and ongoing fear and the abuse that I have been subjected to. I want to respectfully emphasize one last time how much I feel that exposing these opinions and relaying these facts may put me and my children in danger in the future. Despite that, I believe it provides important context that the court needs to be aware of. I respectfully ask the court to consider my safety, my children's well-being, and the long-term impact of these events when making any decisions in the case. Thank you for your time and consideration.
Thank you. Anything else, Ms. Nicholson?
Your Honor, as to the probation violation case, this court gave Mr. Jones an opportunity when it placed him on community control after convictions for assault on a police officer and felony obstructing official business. That sentencing occurred at the end of January of 2026. Within 1 month, we were here with violations. And so it is clear that Mr. Jones did not take advantage of the opportunity the court gave him. The state believed that prison was appropriate at sentencing back in January, and we feel again today that a prison sentence is appropriate on the 24 CR case, and we would ask the court impose a 24-month sentence on that case. Additionally, on the new case, the having weapons under disability and the violation of protection order, this court made very clear to the defendant at sentencing that he will not be able to possess any firearms. There was a conversation about that. He said he understood that. He said he was done with a lot of things. To then hide a firearm under the floorboards of your house, ask a friend to go get it when you realize probation didn't find it the first time, and then also use that weapon, that hidden weapon, kind of as a silent threat, I think just goes to show the attitude that Mr. Jones has and had toward this court when he said he understood that he couldn't have any firearms at sentencing on the original case. So we would ask the court to impose at least an additional 12 months to be ran consecutive to the 24-month sentence on the PV for an aggregate sentence of 36 months. If the court is inclined to leave Mr. Jones on community control with additional sanctions imposed, additional conditions imposed, the state would ask that there be a no contact order as a matter of any community control in the 26 CR case with Sarah Jones.
Anything from probation?
The only thing I would like to note, Your Honor, is that Mr. Jones does have 66 days total jail time credit.
Total on both cases?
53 days on, since he's been I didn't know whether or not you wanted to apply that to the new case or the
What was the total again?
66 days total.
All right, thank you. Mr. Helbling?
Your Honor, we've had a lot of opportunity to discuss this case in chambers. The statute basically, we all know, emphasizes that the terms of sentencing should be concurrent with each other. I know that I've spoken to Mr. Jones extensively about both these cases. He realizes he has violated and has messed up, and that's why he pled guilty today and admitted to the violations. We would respectfully request the court to somehow incorporate, if the court's inclined, some mental health proponent or component to this case. I think that Mr. Jones explained to the court that he is on prescription medication for mental issues. I think given the letter that we just heard from, there is a concern for mental issues on this, and I don't know the extent of what the court could do from that perspective, but I would respectfully request you be placed in some kind of a program. If not, we would request a minimum time that the court would impose, hopefully something more local than in prison, because he has not been in prison before. I realize the court's dilemma on this, but from our perspective, he's going to have to deal with some other issues, I know, in the future, but I think that would still impose a sanction on him that is appropriate for punishment.
Thank you, sir. Mr. Jones, anything you want to say?
I didn't realize how badly I've screwed up until hearing it all out loud. I kept apparently getting myself into thinking that I wasn't so bad, but apparently I'm a monster. I've never meant to hurt my wife or my kids. I apparently just got into bad rationalization. I don't know what else to say.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevance, seriousness, and recidivism factors. Mr. Jones, I can tell you after sitting through the trial back in at the end of last year, I really felt that I was showing a great deal of mercy to you in not sending you to prison for assaulting two officers. Under those circumstances, I thought you got the message. Perhaps I was wrong. Well, obviously I was. You have some issues that you have to deal with, and perhaps maybe hearing this for the first time, what your conduct has done to the people that you love, maybe that'll get through to you. I cannot take a chance with, and I know I was very clear with regard to the weapons. Your behavior, quite frankly, is a little scary. So, the court's going to find it today that you are not amenable to community control, and that prison is necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. So in case number 43461, the court is going to order you to serve 24 months in prison, and on the violation of protection order, 180 days in the Warren County Jail, that to be served concurrent with the 24 months. You have 0 days jail time credit on that case. Under case number 24 CR 42167, the court's going to order you to serve 18 months in prison on count 1, 18 months in prison on count 2, 12 months in prison on 5, count 3 having been dismissed. Those all to be served concurrent with each other and concurrent with case number 43461. The court finds you have 66 days jail time credit under case number 42167. The court does find that you're indigent for the purpose of other fines, costs, or other financial sanctions. You're also subject to the discretionary post-release control. Do you need me to go over that with you again?
No.
All right. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an appellate attorney, that can all be provided to you at no cost. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Helbling?
For clarification, Judge, on the sentence on the old case, I know that you said it's concurrent, but did you say that each one of those counts were concurrent to the other?
Concurrent to each other and concurrent to 43461.
Thank you, Your Honor.
That's all. Thank you. Discussion, you need to get that up there.
After hearing the victim's statement, the judge said Mr. Jones had already been given a second chance but had completely broken the court's trust. He sentenced Jones to a total prison term and made it clear that his repeated choices left no room for further leniency. For more real courtroom cases, subscribe to the channel and watch our next video.